Hello, guys. Today we are going to present our final project, which is going to be Competition Law by Kenny, Kevin, Matthew, myself, Dinesh, Diana, and Safira. Definition: Business competition law can be defined as law that regulates everything related to business competition. KPPU is an independent institution which cannot be influenced by any third party when it's handling, deciding, or investigating a case, whether it's the government or other parties with a conflict of interest.
Legal procedure in kppu. Procedures at kppu are more fully regulated in kppu Decree Number 5, kppu 9, year 2000, on procedures for submitting reports and handling alleged violations of Law Number 5, year 1999. The issuance of this decision shows that kppu can also act as self-regulatory body whose provisions are binding on the wider community. The process of a case at kppu goes through several stages, which can be roughly classified as follows. Indication collection stage. A case may originate from a report from the public, usually as a aggrieved competitor or based on observation of the kppu itself. Thus, in addition to being based on reports, kppu can initiate a case on its own initiative. Indications of violations of Law Number 5, year 1999 are set forth in the form of a written report in Indonesian language, accompanied by evidence, letters, and other supporting documents. Second, preliminary examination stage. The report and file are addressed to the chairman of kppu. If incomplete, the report must be returned to the reporter within 10 working days through a letter from the executive director of the kppu secretariat. The definition of working days here is Monday to Friday. The reporter is given 10 working days from the notification of the incompleteness to add anything that is still lacking in the report. If the reporter is not contacted within 10 working days, it is assumed that the report is complete. The third, the following examination stage. The follow-up examination stage lasts for 60 working days. If necessary, this period can be extended for a maximum of 30 working days. At this stage, the commission panel, determined by the chairman of kppu, may request the assistance of a team of investigators or a working group. The aim is to ensure the quality of the investigation and the analysis of the decision. The authority to implement this belongs to the commission panel, which consists of 3 to 5 people. They may call the complainant, witnesses, expert witness, and other parties deemed to have knowledge of the case. All identities and statements during the examination are recorded in the minutes of the examination. They can also request the submission of certain documents, which in some cases are even classified as confidential. And next. The fourth is the judgment stage. If found guilty, the reported party may be sanctioned with certain administrative measures within 30 working days from the receipt of the notification of the decision, and the reported party is obliged to implement the contents of the decisions. The implementation of the decisions is reported to the kppu. There are 14 days from the notifications of the decisions for the reported party to accept or file an objection. If the period has passed, then the decision is declared to have permanent legal force. In this case, kppu will submit a request for a determination of execution to the district court. If the reported party remains unwilling to execute the execution, kppu may submit the commission's decision to the investigators. The investigation in accordance with the applicable criminal law. And the fifth, the execution stage of the judgment. As stated above, within 14 days from the notification of the decision, the reported party is also entitled to file an objection to the decision to the district court. According to Article 45 of Law Number 5, Year 1999, the district court shall examine the objection and make a decision within 30 days of the commencement of the objection examination. This fast-paced process in practice creates problems. One of them is related to the procedures for summoning, especially if the parties are domiciled abroad. The Civil Procedure Code states that such summonses must be made through Department of Foreign Affairs, and this can take up to 3 months. Next is KPPU sanctions. Although KPPU has the function of a law enforcement, especially business competition law, KPPU is not a special judicial institution for business competition. Thus, KPPU does not have the authority to impose sanctions. The position of KPPU is more of an administrative institution because the authority attached to it is administrative authority, so the sanctions imposed are administrative sanctions.
Illegal per se and rule of reason. Illegal per se is an approach that declares whether a certain argument or business activity is to be inherently illegal without any further proof of illegality. An example of this would be a business doing anti-competitive laws such as price fixing, for example. The rule of reason approach is used in order to determine whether or not a act was considered illegal, even if the act does not have enough evidence to be used against regular law. An oligopoly market is an imperfect competitive market. It is called this because the number of producers and traders within a market is not proportional to the amount of buyers and/or consumers in that market. Secondly, pricing. First, we have the price fixing agreement. A price fixing agreement means that the competitors will raise or lower or maintain prices or stabilize prices at a certain level. B, for a price discrimination agreement. This is a strategy that businesses will use to charge customers varying prices on the same product, depending if they think that they will agree with the sellers of the product that they're selling. Predatory pricing is when a business will illegally lower their prices for their product to a point where it's unrealistically low in order to eliminate any and all competition before re-raising the prices to gain on the monopoly that they have created for themselves. D, for resale price maintenance, or RPM. This occurs if a supplier pressures a business not to sell products below a certain price. 3, market division. A market division is a certain scheme or agreement that essentially allows competitors to divide the markets among themselves, making sure that they get an equal amount of customers for their products. And then, we have group boycott or horizontal refusal to deal. This inhibits business actors from entering into an agreement with the explicit purpose of boycotting other companies. Number 5, cartel. A cartel is when there is a conspiracy or alliance among several different producers of similar products with the illicit intention of controlling the production, price, and sales of those products, allowing themselves to obtain a high monopoly position within a market. Number 6, trust. Trust is an agreement to be able to cooperate by forming a larger company or company combination while being able to maintain the survival of each company or individual member. This aims to control the production and/or marketing of goods or services. Lastly, number 7, oligopsony. An oligopsony is an agreement that aims to jointly control the purchase or receipt of supplies in order to control the price of goods and/or services in the relevant market as specified in Article 13 of the Antitrust Law. And then,
We also have what we call the vertical integration. A vertical integration is a business strategy in which a company controls multiple stages of its production, process, and supply chain. We also have the sealed agreement, which is a business actors are prohibited from entering into agreements with all other another actors that limits who they are able to resupply their goods, services towards. Another is business actors are prohibited from entering into agreements with other parties that requires the receiving party to purchase goods, services from the supplying actor. The third one is business actors are prohibited from entering into agreements regarding to prices or discounts on goods or services, which requires the actors to receive goods or services from all other actors who receive goods and services from supplying actors. Last one, we have the agreement with foreign parties. Agreement with foreign parties contain provision that may result in monopolistic practices and or unfair business and competition as stimulated in Article 16 of the Anti-Monopoly Law.
For the last part, we are going to have intellectual property in competitive law. Competition law generally provides exception on the basis of agreements, such as intellectual property rights, which are IPR agreements. IPR is an incentive and reason for granting monopoly rights and protection because IPR requires resources and time to obtain. The IPR law itself guarantees that patents and other inventions will be given protection before they can become public domain. This factor is decisive for companies because this incentive is considered a way to dominate the market but does not constitute a violation of the law itself. With that, our presentation is concluded, and thank you for listening.